Here's the question for today. I have a buyer purchasing a property and the homeowner association wants to charge them a, quote, move-in fee and a, quote, transfer fee. And the escrow company says that the buyer must do what the CC&Rs say, which is that the buyer must pay these fees. Escrow is calling it an industry standard. The purchase and sale agreement has the box checked on line 13 stating that charges and assessments will be prepaid in full by seller at closing. Who must pay the HOA move-in and transfer fees? Pause. The answer to this question requires an interpretation of the contract language. The terms of a contract mean whatever the parties intended for the terms of the contract to mean. And if the parties have a dispute and can't agree as to what the terms of their contract required, that's when a Superior Court judge enters the picture. And a Superior Court judge will interpret a contract by either reading the plain language of the contract, and if that doesn't do the trick, then the Superior Court judge will interpret the meaning of the contract by considering the evidence submitted by the parties with respect to their intent with respect to the meaning of the language. So the answer I'm going to give you is my opinion. I am not one of the parties to this contract, and I'm not a Superior Court judge who would interpret the language of this contract based on the information submitted to me in an argument. But here's my thought. The charges and assessment provision is placed into the purchase and sale agreement to prevent buyer from being blindsided after closing with fees that the buyer could not anticipate prior to closing. And why couldn't the buyer anticipate these charges prior to closing? Because knowledge of these charges was within the exclusive province, if you will, of seller. For example, seller may be a developer, and as a developer, seller knows that one of the conditions for subdivision of the land was that when a buyer goes to pull a building permit from the local jurisdiction, buyer is going to have to pay several $1,000s in school impact charges. Or seller who has lived in the property for a few years and been paying a sewer bill knows that part of what they pay every month in their sewer bill is referred to as a sewer capacity charge. And this is a long-term debt that the seller has that they have chosen to pay monthly rather than in a single lump sum. Buyer won't know that seller is paying the sewer capacity charge over the long haul as a monthly fee as opposed to a single lump sum until buyer takes possession of the property and has to pay the sewer bill. Buyer of the raw land may not know that there's a school impact fee that has to be paid until they actually go to pull their building permit, because typically school impact fees and sewer capacity charges are not recorded against title to property. Often the case is the same with respect to homeowner association special assessments. Now, if we're talking about a regular monthly assessment, those are known. They are typically referenced in the set of CC&Rs that's recorded against title to the property. And buyer, by knowing that there is a homeowners association, is on notice, if you will, to determine what the amount of the homeowner association monthly fees are. But there's no way that a buyer can anticipate that a homeowners association imposed, for example, a special assessment a couple of months ago, giving its members 6 months to pay the special assessment. So buyer purchasing that property has no ability to know that this special assessment has been levied but won't be due until after closing. These are examples of why the charges and assessments provision is included in the purchase and sale agreement. It's my opinion that this example regarding move-in or transfer fees charged by the HOA fall squarely in the same category. Knowledge of the charge for the transfer and move-in fee is known to the seller, or should be known to the seller, because it's the seller's HOA. Remember, the seller owns the property right now, so the seller is the member of the HOA. It's the seller's HOA that has created the opportunity or the obligation for this charge to be assessed against future buyers. But these fees are not typically recorded in any written document that's recorded against title. They're not going to show up on a title report. Buyer coming in to this association will have no way of knowing that the HOA is going to charge a move-in or transfer fee unless seller puts them on notice of that. So when a buyer takes the only action that buyer can to prevent themselves from being blindsided by this obligation, the only thing buyer can do is to check the box under charges and assessments, obligating seller to prepay in full at or before closing. When buyer does that and seller agrees, seller has the obligation to carve out from that obligation any charges or assessments that seller intends to hand to buyer. So if escrow is right, and that the industry standard, whatever that means, and frankly it doesn't mean anything, but if there were some reason that these move-in and transfer fees should in fact be the obligation of buyer, then seller, it's your responsibility when you agree to pay charges and assessments in full at closing to carve out this language. Seller will pay charges and assessments in full at closing except that. And you're going to have to write this on a Form 34 or some other blank space. Except that buyer will pay HOA required move-in and transfer fees at the time buyer takes possession of the property or whenever it would be triggered. So in this question, we're discussing move-in and transfer fees assessed by the HOA, but the example applies itself to any charge or assessment that seller intends to carve out of seller's obligation to prepay in full at closing. The smart buyer's broker always checks the box that says seller will prepay in full at closing. That provision places on the seller the obligation, the affirmative obligation, to put buyer on notice of any charges or assessments that buyer is expected to pay themselves. And then buyer is going to have to separately agree to make those payments. That's the purpose of the charges and assessments provision. It works in this case to prevent buyer from being blindsided by what can sometimes be pretty hefty fees moving into an HOA. I hope that makes sense. I have a feeling this might be a controversial answer. I don't think everybody is going to universally agree with my interpretation of this provision. But the purpose of the provision is to prevent buyer from being blindsided. If you want to talk about this question or any other, send an email to me, legalhotline@warealtor.org. Be happy to discuss it with you further or to answer any other question you might have. Thank you for being a Washington Realtors member.